Okay, welcome back to the second video. Just a reminder of where we are in the course. We are talking about various kinds of land use controls. We just finished talking about private agreements that can be imposed by landowners in order to control land use, in order to respect or further private goals for how land will be used in the form of easements, covenants, and servitudes. And we talked about the sort of possibilities and limitations inherent in those different kinds of private duties that can be imposed on land to run with the land. Now we're going to talk about the common law. We're going to talk about, in particular, about the nuisance doctrine. And then the next couple of classes will be talking about zoning and about the eminent domain power under the Constitution. So this is the restatement of torts definition of nuisance. Now, unlike many of the restatement sections that we've read throughout the semester, this one actually has adopted into law in many places. And even for the places that don't adopt the restatement definition of nuisance, this is very, very close to the common law definition that comes to us from the idea of quiet enjoyment of land. And a nuisance is an interference with the quiet enjoyment of land. And notice the definition here, a substantial, non-trespassory interference with the use and enjoyment of land. This is a tort. And each one of these words matters, right? Substantial, interference must be substantial, must be non-trespassory because trespass is a separate tort, must be an interference with the use and enjoyment of land. So each one of those words matters. And sometimes there are arguments about is this a trespass or not? If it's noise, is it or vibration, right? That is an interference that is non-trespassory because nobody's going onto the land. A place where this really comes out is in the pollution context, because people frequently try to argue that air pollution or water pollution is a trespass, and most courts have found that in fact, nuisance is a law that governs that, not trespass. And so let's go to the next slide. Okay, like I said, each one of these critical terms, substantial, non-trespassory, interference with private use and enjoyment of land, will have to be demonstrated, and you have to think about what does each term mean and produce facts to demonstrate that each one of these terms has been met. So there are multiple vectors upon which you can consider nuisance. The first is private versus public nuisance. Public nuisance affects the rights of everyone in a community, whereas a private nuisance affects specific individuals. And that's going to depend on the particular harm that is alleged and is going to impose limits about who has standing to sue and what remedies are available. Now, just to give you a concrete example, I've been working with a community in Jamaica, New York, around the burdens imposed by nearby waste transfer stations. So the private nuisance allegations are that things like odor and particulate matter that affect neighbors' ability to use their houses. So this is individuals saying, I can't open the windows in my house, I can't have barbecues, I can't use my backyard. Those are private nuisance allegations. By contrast, the odor and particulate matter also interferes with use of a nearby public park. Right? It's the same kind of interference as for the private residences. The odor makes it really unpleasant to be there. The trees are being harmed by the air pollution. But this is a public claim because it affects anybody who uses the park and will affect everybody who uses the park in the same way. That is a claim that must be brought by the government on behalf of the public or by a private individual who has a unique injury like a tennis coach who, say, can't offer classes in the park anymore, has an injury that is different from the odor injury or the lack of foliage injury that everybody shares equally. So that's the difference between public nuisance and private nuisance. And then there is a second vector to think about nuisance of intentional nuisance versus negligent nuisance, in which different kinds of conduct are held accountable. And we'll look at both of those. Right. So going back to our friend the restatement, defining who can be liable for the non-trespassory interference with use and enjoyment of land, indicates that there are two different ways to be liable, right? One is liable for conduct that invades another interest in the private use and enjoyment of land if the invasion is, number one, intentional and unreasonable, right? That's the intentional tort of nuisance, or unintentional, but negligent, um, or for abnormally dangerous activities. So what's the test for negligence, right? Think back to your torts class. Duty, you have to show duty, breach, causation, and damages to make a case in negligence. Most nuisance case, or not, I don't know about most, many nuisance cases are intentional torts, alleging that the conduct is intentional and the impact is unreasonable. Right, so when is conduct intentional, right? In order for there to be an intentional nuisance, there must be intentional conduct, and that conduct must interfere in a substantial and unreasonable way with use and enjoyment of land. And I do just want to point out, again, for the comparison to trespass, which we've looked at over and over again throughout the semester, for trespass, there's no reasonableness inquiry, right? There's either a trespass or not, but in terms of nuisance, there has to be an interference that is substantial and unreasonable. A trespass doesn't have to be substantial, it doesn't have to be unreasonable, it just has to be a trespass. So when is conduct intentional? Right? The actor doing the conduct doesn't have to intend the harm. They just have to intend the action that causes the result, and has to be aware that their actions are substantially likely to cause the result. And it's not a matter of, did I try hard to avoid causing harm? It's if you do the thing and the thing is likely to cause the outcome that is an unreasonable interference with somebody else's use and enjoyment of land, then that is the tort of intentional nuisance. Going back to the distinction between a private nuisance and a public nuisance, if somebody wants to bring a private nuisance claim, they must demonstrate, first of all, that they have a possessory interest in the affected land. Because again, nuisance is the unreasonable interference with use and enjoyment of land. And if you don't have a right to use the land, some kind of an interest in the land, then you cannot bring a claim for private nuisance. So that's number one. Plaintiff has to show that they have a possessory interest in land. Then number two, the plaintiff must show that the defendant has performed an act that interfered with the plaintiff's use and enjoyment of that land. And three, that the use was substantial and unreasonable. So the kinds of things that frequently get alleged as private nuisances are vibration, pollution, smoke, foul odors, excessive light, loud noises. Conduct that poses an unreasonable interference with somebody's use and enjoyment of their property. And again, unlike a private nuisance, which is about an individual with a property right that is being interfered with, a public nuisance is an unreasonable interference with a right that is common to the general public. So things that interfere with public health, public safety, public peace, public comfort, public convenience, or public welfare, or conduct that is prescribed by a statute, ordinance, or administrative regulation can give rise to a public nuisance. So going back to my example in Jamaica, New York, right, the interference with the park is a public nuisance because it interferes with the general public's ability to enjoy the park in comfort and safety and health. The kinds of things that might give rise, more examples of things that might give rise to an allegation of public nuisance is blocking the street, racing motorcycles in the street, storing hazardous waste without a permit, illegal bars, unlicensed gambling, or fight clubs. Public nuisance also gets used a lot in the environmental context. Anything that pollutes the waters of the United States or the air in general can be a public nuisance, right? If it interferes with somebody's ability to open their windows because it makes it stink in their house or makes it dangerous to breathe in their house, that would be a private nuisance. If it is simply pollution is being emitted into the air, the allegation is it would be a public nuisance. So focusing on different pieces of the same conduct could give rise to a public nuisance and a private nuisance. Okay, so before we talk about Boomer versus Atlantic Cement, which is one of the definitive cases in this area, I wanted to show you what the cement plant looks like now. It's still there. It is no longer the biggest cement plant in the world like it was when the litigation took place, and it's now owned by a company named Lafarge. But as you can see, it is an enormous installation, and it is now regulated under federal and state law, but I would imagine that living nearby still is not the most pleasant of circumstances. Okay, so let's look in detail at the case. Right? So what were the neighbors' allegations of nuisance? Right? They were alleging that their reasonable use and enjoyment of their property was unreasonably interfered with because of dust, smoke, and vibration emanating from the plant. And in fact, the court found that the interference with their property, right? They were alleging private nuisance, just to be clear, because they were alleging that their nearby properties were impacted negatively by the cement facility's operations. The court found there was a nuisance. And so the issue on appeal was not, is there a nuisance, but what should the remedy be for that nuisance? At the time, New York law required that a nuisance be enjoined. So the issue that the court is grappling with is it doesn't want to enjoin the largest cement facility in the world from operating because neighbors are unable to enjoy their property. And notice sort of what the court does here, right? The court says it performs its essential function when it decides the rights of the party before it. But then instead of asking, does Atlantic Cement cause a nuisance? And will an injunction abate the nuisance, which is what the law in New York required, the court sort of pulls back and talks in a big general way about air pollution generally. It doesn't focus on the actual question before it, is there a nuisance? And if so, the neighbors are entitled to for the nuisance to be enjoined, but instead focuses on the wider social implications of issuing an injunction in this context. Right? And the court says we can't solve air pollution as a byproduct of private litigation. That's a job for the government. And right, what we see, if sort of making a parallel to today, right, what we're seeing in our children's trust litigation and the many, many suits that have been brought in alleging torts in the climate context is a resort to nuisance doctrine because the government is not doing anything to regulate or not doing enough to regulate. But what we see in the 70s is, again, in this case, is what we're seeing now in the climate context. We have a problem that needs significant coordinated action to solve, and the tools don't exist or are inadequate. But the Boomer Court is quite fascinating because the court actually asked the question, should we resolve the litigation between the parties now before us as equitably as possible? Or should we uh, seek promotion of the general welfare? Right, which is sort of a bizarre question for a court to ask because it's a cardinal rule of our system that courts resolve the disputes before them. But again, the court does not want to be the one making decisions about pollution. Remember, it's 1970. We have had this massive growth in industrial production. This same dispute is being fought out across the country. And courts, first of all, as a matter of institutional competence, think that these are questions that should be decided by legislatures, not courts, and that there need to be systemic choices made. But that's not really how courts work, right? Because a question comes before the court and the court has to decide it. Unlike a legislature, which can always opt not to pass a law or send something for more study, courts don't have that luxury. Courts have to decide the cases that were before them. So the court here, posing this question of should we just decide this dispute on New York law based on the people who are before us, in which case Boomer gets an injunction, or should we ask broader questions about whether, like, who's the appropriate decision maker about this question about air pollution? And the court, instead of applying the existing New York law, which is if you prove a nuisance, you get an injunction, introduces a balancing test saying, well, how bad is the nuisance and how socially useful is the conduct? This, again, was not the law in New York before this case. And the court here says, yeah, the total damage to plaintiff's property, no matter how bad it is for those people, is relatively small in comparison with the value of the defendant's operation. Right? They're balancing how much are the plaintiffs injured versus how much is this operation worth. And what that does is it essentially gives Atlantic Cement something akin to a pollution easement. Because the court doesn't say there isn't a nuisance, right? Remember, they're not fighting about that on appeal. What they're fighting about is what's the remedy. Should the remedy be what New York law requires, an injunction, or should it be something else? And the court here says, we think it should be something else. We think it should be damages. So once Atlantic Cement pays the damages, though, they have something akin to a pollution easement, a permanent right to pollute plaintiff's land, even though the plaintiffs didn't want to sell an easement, and in fact wanted the nuisance abated. So what do you think that does to incentives to try to solve this problem, right? If Atlantic Cement pays money and thereby permanently and totally compensates the landowners for the harms they've suffered forever, because that's what the court says, that sort of destroys any incentive they might have to work on reducing their impacts. And that was a big criticism of this case. And ultimately, a couple years later, the Congress passed the Clean Air Act and began regulating emissions from facilities like Atlantic Cement. So, right, remember, the test is there an unreasonable interference with plaintiff's land? And there are two different ways to assess that. The law in New York had been a threshold test. Does the conduct impose too great a burden on the use and enjoyment of land, right? That's a focus on the impacts to the affected landowner who's saying, my quiet enjoyment is being unreasonably interfered with. What the court in Boomer did was instead introduce a balancing test. Do the harms from the conduct outweigh the utility of the actor's conduct? And that focuses on economic rationality and less on the impacts to the complaining landowner. And obviously, that is a rule that is going to allow much more interference by large corporate actors than would be allowed by private actors. And one place, if you're interested, one place to look at how this litigation has played out is in North Carolina in litigation against concentrated animal feed operations by surrounding landowners alleging nuisance. So the restatement is all in on the balancing version of deciding what is unreasonable, and in fact identifies factors to consider to assess the gravity of harm. And they're exactly what you would expect. What's the extent and character of the harm? What is the suitability of the challenged use to the locality in question? What is the social value of the use that is being challenged? And how hard would it be for the plaintiff to avoid the harm? Like, at what point can we just say, yeah, you know what, you should close your windows? So this is very much a vision that is not about protecting individual landowners, but is looking at the broader question of conflicting uses and what to do about them. So, right, the remedies that will be provided for a nuisance, right, after Boomer, we see, the different possibilities. So the traditional answer is that if a nuisance is found, it should be abated. So grant an injunction, abate the nuisance. And again, courts have been very reluctant, and not just in Boomer, but going back to the earliest days of the Industrial Revolution, courts have been very reluctant to enjoin large factories and polluting facilities that are creating a nuisance for surrounding landowners, particularly when those surrounding landowners are smallholders and are small farmers or residences of not tremendous amounts of value. So there's definitely a class thing there as well. Second remedy is the remedy in Boomer, which is to award somebody who proves a nuisance permanent damages and then allow the activity to continue. And then the restatements goes even farther and says when the social utility of the conduct outweighs the injury to the landowner who has shown a nuisance, then you simply deny all relief and allow the activity to continue. So thinking back to things we've talked about in this class, the litigation around spite fences is a nuisance issue. If you think about the Pra versus Moretti case, right? Pra was claiming that Moretti's house was a private nuisance because it was casting shade on his solar collectors. And the principle here is that the sticks in the bundle need to be reconciled. Right? The rights of neighboring landowners are relative, and the uses by one should not unreasonably impair the use and enjoyment of the other. And right, we saw that in, as I said, in the Pra versus Moretti case. We saw that in the spite fence cases, and famously, Justice Holmes, in a case that we're not going to read called Hadachek, described a nuisance as a pig in a poke, a thing in the wrong place. And we're going to pick up on that phrasing again when we look at zoning. So I asked you to read Thompson versus Grieve, which is a nuisance action that is full of very similar allegations to the allegations in Boomer Boomer versus Atlantic Cement. But instead of smallholders versus a large corporation, this is two smallholder neighbors. And you can see that the same standard is applied very differently in this case. That same restatement nuisance standard test for unreasonable injury, right? So this action is brought by the plaintiffs, Mr. and Mrs. Thompson, and they're seeking to enjoin the defendant, the Greaves, Mr. and Mrs. Greaves, from using their wood-burning stove to heat their home. And the allegation is that the smoke from the wood-burning stove is entering the Thompsons' house and causing them injury. And the court applied the same restatement test for unreasonable injury that was used in the Boomer case, right? The assessment here, though, is radically different. The court says to have the use and enjoyment of one's home interfered with by smoke, odor, and similar attacks upon one's senses is a serious harm, right? So in both cases, the court says, yeah, this is a nuisance, right? Smoke, odor, dust problems. However, here, the court is not comparing that burden on the landowner, in this case, the plaintiffs, to a multi-million-dollar cement industry, but another person wanting to use their own home. And the court says that the social value of allowing people to enjoy their homes is great, but that the Greaves wood-burning stove doesn't really have any particular social value, right? Other than that I can do what I want with my home. And pitting the I can do what I want with my home and therefore I can have a wood-burning stove against the reality that the neighbors have to close their windows to avoid breathing in the dirt, and even that doesn't help, and that their really only option if they want to avoid this harm is to move, right? Here, the court says those two things don't balance out, and in fact, the complaining homeowner's interest should be given greater weight than the Greaves' interest in using their property the way that they want to, which is to have the wood-burning stove. Same exact injury, same exact allegations of nuisance, but a very different result in terms of the willingness to enjoin the activity. Right here, the court says that if this extension to the chimney that you see circled here in this drawing, right, if that doesn't resolve the problem, then the Greaves might be enjoined from the conduct entirely, meaning that they couldn't burn their wood and they couldn't use their wood stove to heat their house. I just want to emphasize again how much this result differs from Boomer versus Atlantic Cement, not in terms of what the nuisance is, right, but in terms of who the defendant is and their power and what the court interprets to be the social utility of their conduct. That leads to a dramatically different result. Here, the court says, yeah, we're not just going to award the Thompsons muddy damages and then say, you're compensated, just live with it. Here, like they did in Boomer, here the court says, no, this nuisance must be abated. So the lesson to draw from this is twofold. One is about the test. The other is how much these nuisance tests can be about power in society rather than abstract balancing. I did want to show you one other thing that is not in your book, but I think is interesting and worth talking about. And what I wanted to show you is this image of the Trail Smelter in 1927. So the Trail Smelter arbitration is the birth of international environmental law. It was a dispute between the United States and Canada over pollution from the smelter, which at the time was the world's largest, in Trail, British Columbia, that was crossing over the border into the United States, causing damage to land in Washington and Idaho. And this, for reasons that are complicated and have to do with sovereignty and actually long arm statutes and the ability to sue, this became an international arbitration rather than tort litigation in either British Columbia or in Washington or um, Idaho. So the Trail smelter, as I said, was the biggest smelter in the world, and it was causing tremendous problems in the town of Trail, which visiting writers described as an outcrop of hell because of all of the smoke. And so the solution that Trail British Columbia came up with was, let's build bigger smokestacks. If we do that, then the pollution will go away. And I have air quotes around away. And that's what they did. They built 600-foot stacks, and all of a sudden there was no more pollution problem, or at least no horrific pollution problem in Trail, British Columbia. Instead, there was a pollution problem, dozens of miles away across the border in Idaho and Washington. And I just wanted to point out to you that the solution that the court recommends in the Thompson versus Grieve case, build a higher smokestack, right, was the solution that the smelter adopted here to solve its local pollution problem, and all that did was create a pollution problem somewhere else. So, it's not that the Boomer Court was wrong when they said that this is a problem that needs a systemic solution. It's just that the tools that we have of nuisance, courts are very reluctant to actually enforce them when it would be sort of expensive, or very powerful economic actors would be impacted. And so that brings us to the limitations of nuisance and common law land use controls as a way to solve these problems of incompatible uses. Nuisance law, first of all, is reactive, right? It responds to a demonstration that one's quiet enjoyment of property has been unreasonably interfered with. So nuisance law is not prospective. It is retrospective, addressing harms that have already occurred. And if what you want is to not have harms, that's perhaps not the first or best choice. And nuisance law, right, it relies on a lawsuit brought by the person who has suffered the unreasonable interference. And as we know, bringing lawsuits can be very expensive. It also can be very difficult and unpleasant. So again, not an ideal solution. And then you come to the question that the court in Boomer was really grappling with of, are courts the appropriate venue for resolving these questions when they're questions about the incompatibility of uses? Right? The point wasn't necessarily that Atlantic Cement was bad or a bad actor or that it wanted to harm its neighbors, but cement making is a very dirty process. And there's really no way to do that, or at least certainly in 1970, there was no way to do that without negatively impacting neighbors who wanted to have their farms or wanted to live, and that the uses were incompatible. And right, that's what these problems that I'm articulating here are part of the reason that there's been this tremendous growth in the private land use controls in the form of covenants and equitable servitudes. Right, those were attempts to resolve the problem of how do we prospectively prevent land uses that will injure what we are going to decide is the highest and best use of the land collectively, and how are we going to resolve that, right? The idea in the private land use controls was that the landowners together would make choices, and that would prospectively shape the terrain. We also already talked about the limits of those private land use controls, and now you can see the limits of this common law doctrine. What we're going to start talking about next class is zoning and how zoning arose as an attempt to solve these problems. And we'll talk about where it was and was not successful. And so I want to leave you with something that's ripped out of the news this week that was brought to my attention by one of your alert classmates. And this house, which is being built in Fairfax, Virginia, is a bridge between HOAs, private covenants, nuisance law, and zoning. What you see here is a house that has decided to build a very large addition. And you can see it's an addition that is completely out of scale with the rest of the neighborhood. The neighbors are alleging that without the housing even being completed, it is depriving them of loss of light, loss of air, casting shadows on their house, and decreasing their property value. Now, the point of zoning, as we're going to talk about, is supposed to be to promote public health, safety, and welfare, in part by preventing uses that would be akin to a nuisance. Now, this particular case is very interesting because there is no HOA in this neighborhood, so there are no private land use controls. This building, in theory at least, complies with the zoning restrictions. So that leaves the neighbors trying to figure out, well, is there anything we can do to block this? Now, the zoning board is already talking about changing the zoning, and there are discussions in this neighborhood about maybe creating an equitable servitude, but that doesn't answer the question of what about this particular facility. And I want to tell you something. I did a little digging, and one of the interesting things is that this building, right, it doesn't exactly comply with the zoning. The height limit for the zoning is 35 feet, and it complies with that. But as the code stands, there's no rule keeping the height and width, the height within a certain width to like to disperse the bulk of the building. And so as a result, right, this was built, but it turns out that the required zoning setback from the neighbor's house is 8 feet. And unfortunately, this construction is only 7 feet 6 inches from the property line. So it doesn't comply with the zoning, and we'll talk next class about what that means. And guess why they made the mistake? Going back to some of the adverse possession stuff we've been talking about, they made the mistake because they were trying to comply with the zoning. But they made the mistake because they measured from the fence, not from the property line. And as we know, fences don't necessarily match the property line. So it turns out that the fence was 6 inches from the property line. And as a result, there's a stop work order on this building, and we will see what happens. So I'm going to stop there, and we will talk about zoning next time.